pleasure that I extend a warm welcome to all the esteemed dignitaries present at this remarkable initiative for the training program on creation and conversion of existing courtrooms into vulnerable witness deposition centers. This gathering represents a significant step forward in our shared dedication for maintaining the highest standards of judicial integrity and excellence. It is with profound honor and a deep sense of privilege that I extend a most respectful and warm welcome to Honorable Ms. Justice Geeta Mittal, Chairperson of the Vulnerable Witness Committee. We are indeed privileged to benefit from her seasoned perspective as she presides over this session. Besides her distinguished career as a judge, Justice Mittal has been a pioneer in advancing the cause of vulnerable witnesses in the criminal justice system. Her efforts culminated in the establishment of India's first vulnerable witness courtroom in the trial courts of Delhi, a landmark initiative that had since served as a model for the jurisdictions across the country. Her presence today is not only a matter of immense pride, but also a source of inspiration as we collectively engage in strengthening the justice delivery mechanisms, particularly through the implementation and enhancement of vulnerable witnesses deposition centers. We are deeply honored to welcome her and look forward to the insights she will share with us. I request Sri Satyaprakash Sinha, Registrar Establishment, High Court of Jharkhand, to welcome Honorable Ms. Justice Geeta Mittal with a book and a plant. Ma'am, please. Sir, please. It is my profound honor to extend a warm and respectful welcome to Honorable Mr. Justice Ananda Sen, Judge, High Court of Jharkhand, come Chairman, Vulnerable Witness Deposition Center Committee, Jharkhand High Court. His Lordship's distinguished presence adds immense value to this training program, and we are deeply privileged to have his continued support in our collective endeavor to make justice system more sensitive, accessible, and secure, particularly for vulnerable witnesses. We are confident that His Lordship's insight will provide valuable direction as we explore the modalities and challenges involved in the creation and conversion of courtrooms into vulnerable witness deposition centers. I request Sri Rajesh Saran Singh, Principal Secretary Law, Government of Jharkhand, to welcome Honorable Ananda Sen sir with a plant and a book. I am deeply honored to extend a warm and respectful welcome to Honorable Mr. Justice Anil Kumar Chaudhary, Judge, High Court of Jharkhand, come Member, Vulnerable Witness Deposition Center Committee, Jharkhand High Court. His Lordship's presence at this training program is a testament to his continued commitment for strengthening the judiciary's role in delivering inclusive and accessible justice. We remain profoundly grateful for His Lordship's encouragement and insightful leadership. I request Sri Satyakam Priyadarshi, Director in Charge, Judicial Academy, to welcome Honorable with a plant and a book. I also welcome Sri Ravindra Dutt Sharma, Registrar, Vulnerable Witness Committee, and Sri Ajit Jha, Director, Vulnerable Witness Committee. Sirs have been a true pioneer while we were organizing this training program. In the same spirit, I extend my deepest appreciation and a warm welcome to all the participating judicial officers, public prosecutors, police personnel, engineers from the Building Construction Department, and all other distinguished attendees. Your valued presence reflects a collective commitment to judicial innovation and collaborative growth. Thank you. Now I request Honorable Mr. Justice Ananda Sen, Judge, High Court of Jharkhand, come Chairman, Vulnerable Witness Deposition Center Committee, Jharkhand High Court, for the introductory remark. Honorable, please.
Good morning to you all. Respected Madam Justice Geeta Mittal, my brother Justice Anil Kumar Chaudhary, and all the participants. In recent years, an alarming trend has emerged in our country. More and more witnesses are turning hostile, leading to acquittals in numerous of cases. This has become a deeply unpleasant reality for Indian judicial system. Despite having a well-established legal framework and being the world's largest democracy, India's conviction rate remains relatively low compared to other developing nations. While defective investigation is certainly one of the contributing factor, the frequent occurrence of witnesses turning hostile during the trial is among the prime cause of this low conviction rate. It's hard reality that even genuine witnesses, even the victims, in many number of cases, often are vulnerable, and they are manipulated and intimidated into turning hostile during the court proceedings by the politically or financially powerful or affluent accused. The Witness Protection Scheme of 2018 classifies witnesses into three categories based on threat perception. Category A, where there is a threat to life. Category B, threat to safety, reputation of property. And C, risk of harassment and intimidation. The term vulnerable witness emerged through Delhi High Court guidelines and gained legal reinforcement in Mahendra Chawla's case, where the Supreme Court upheld the right to testify in a safe, impartial environment as a fundamental right under Article 21 of the Constitution, thereby enforcing the importance of protecting such witnesses throughout the entire judicial proceeding. In Smruti Tukaram Badade's case, the Honorable Supreme Court emphasized the need for safe, inclusive, and barrier-free environment for vulnerable witness. The Honorable Supreme Court had acknowledged that right to fair trial under Article 21 includes dignified treatment of vulnerable witness who may face psychological, emotional barriers beyond physical ones, necessitating infrastructural changes and stakeholders' sensitization. Several directions were given, like in respect of victims of sexual assaults, person with mental illness and impairments, witnesses who are under threat as per Witness Protection Scheme, and other vulnerable witness. All the high courts were directed to notify or modify the Vulnerable Witness Deposition Center. There was a creation of permanent Vulnerable Witness Deposition Center committees for implementation and training. Estimate infrastructure, manpower needs for at least one such type of center per each district, and submit cost estimates to the state governments for immediate funding. Constitutional and national level the Vulnerable Witness Deposition Training Committees was constituted, where Madam is the chairperson and is taking keen interest, and because of the interest taken by her, we are seeing change now. Then there was an order to the states and the Ministry of Women and Child Development to fund, support, and coordinate implementation of this. Witness, as we know, it is the most important pillar of our justice delivery system. A pillar in our country is oftenly defaced, and so the witnesses have been in these years. No one has thought for these witnesses. And if you see, until and unless we get the witnesses and get their recording statements properly, we cannot deliver justice. So we have to think now a time has come that this important pillar has to be saved for our justice delivery system. This persistent neglect of witnesses and the vulnerability caused psychological disaster underscores the urgent need for a robust monitoring mechanism. In conclusion, I'd like to say that ensuring the safety and respectful treatment of vulnerable witnesses is ethically and legally essential. The court should ensure the safety and well-being of vulnerable witnesses, which may include effective implementation of Witness Protection Scheme of 2018, which ensures physical protection, anonymity, in-camera proceedings, day-to-day trial, reallocation, and financial support, along with judicial directives which can signify enhanced public confidence and improve the quality of witness testimonial, thereby reinforcing the criminal justice system. Thank you.
Thank you so much, Lordship, for the sensitizing and insightful words. Witnesses are indeed the most important pillar of the justice delivery system and the challenges that they face while depositing in the courts. Moving further, now I request Honorable Ms. Justice Geeta Mittal, Chairperson, Vulnerable Witness Committee, for the session. Ma'am, please, ma'am.
Brother Anando Sen, Brother Anil Kumar Chaudhary ji, Shri Nikesh Kumar Sinha, Registrar Judicial, Shri Rajesh Sharan Singh, Principal Secretary cum Legal Remembrancer, Shri Satyakam Priyadarshini, Director in Charge, Jharkhand Judicial Academy, Shri Pankaj Kumar, Chief Engineer, Building Construction Department, and his colleagues from the department, officers of the police department, learned registry members, my sister and brother judges who are present here, and all those who have joined online. Prosecutors, legal aid lawyers, the staff of the Judicial Academy, Namaskar, Pranam, Johar, Sat Sri Akal, Assalamu alaikum, salam. Jule is the greeting in Ladakh. Vanakkam, जो हमारा greeting है South India में. A good day to all of you. मैं open in remarks के साथ करती हूँ हमेशा, because the whole program is a desire, an intention, and an effort to be inclusive, to include the most marginalized persons in the justice delivery system, that is the witness. And हमारे सारे greetings, all the greetings with which I've opened and greeted you are inclusive greetings. It doesn't matter कि आप अमेरिका में बैठे हैं या ऑस्ट्रेलिया में. If I had opened by saying good morning, तो मैं Australians को exclude कर रही होती जहाँ good evening था. But unlike this is exclusion, which is provided by even greetings of other places, you know, we are so inclusive in the way we have thought, in the way we greet each other. And so inclusion and equality should be the mantra with which every person in this room, be it in the justice dispensation system, be it the police which is doing protection, be it the engineers who are ensuring कि हम सब अपनी duties discharge कर सके, be it the prosecutors, be it the lawyers. This is the spirit with which we should be guided. And this is the spirit of the program. And my effort today is to bring home, to impress, to emphasize this facet very important facet which is recognized by the Constitution of India, which has shown, which has, mandated the guarantee of equality to every person, every human being in this great country. So this is what I wanted to tell you all, that this is the spirit with which you should attend this training program. The second thing I want to do is I want to thank the engineering staff and the architects who are present in this room and the police personnel. आप लोग सोच रहे होंगे कि आपको क्यों ज्वाइन किया है, कि इसलिए ज्वाइन किया है क्योंकि हमारी कोशिश ये है कि हम सिर्फ इंफ्रास्ट्रक्चर ही ना क्रिएट करें, सिर्फ कानून को ही ऐसे इम्प्लीमेंट ना करें जिससे कि वी आर एबल टू जॉइन विटनेसेस एंड मेक देम कंफर्टेबल इन द सिस्टम, बट आप समझ पाए कि हम क्यों कर रहे हैं ये और ये क्यों एसेंशियल है. ब्रिक एंड मॉर्टर की बिल्डिंग बनाना तो मुश्किल नहीं होता, आप नक्शा देंगे, आप प्लान लेंगे और आप बना देंगे, लेकिन टू इन्फ्यूज स्पिरिट इनटू इट, engineers की अंडरस्टैंडिंग के बिना वी कैन नॉट डू इट. The other thing I'd like to point out is that today I will demonstrate to you that why you don't need fancy budgets. जब से मेरी अपॉइंटमेंट हुई है, I'm traveling the length and breadth of this country, एंड बहुत हाई कोर्ट से मुझे ये रिपोर्ट मिला है कि हम लैंड अक्वायर कर रहे हैं, इसलिए अभी लैंड ही नहीं है. अब मैंने दिल्ली जैसी जगह में जहाँ एक्सपेंशन का स्कोप नहीं है, वहां पे बिना बजट के, बिना किसी चीज के एक वल्नरेबल विटनेस कॉम्प्लेक्स क्रिएट किया था 2012 से 16 September 2012, and we have gone to every district in Delhi. I see no reason why able engineers, able judges, able leadership is not able to create the same facilities in every district in the country, not only every district, in every court. And I want every judge to be able to craft such a facility from their individual courtrooms. कुछ नहीं चाहिए आपको, एक लैपटॉप चाहिए, एक पीसी चाहिए. आज की तारीख में तो the Supreme Court and the government has equipped even the junior most munsif, junior most civil judge, junior most sub judge with all this equipment. You have Bluetooth, you have all these mics and microphones and speakers available. There's no reason why you can't be ingenuous and craft this facility. We need the police here because you're responsible for the most important part, which enables a judge to discharge his duty, that is criminal investigation. You guide the witness through the entire process from the time a police ki complaint lodge hoti hai, medical examination, till the last stage, which is the rendering of the judgment. So that is the reason you are here. And prosecutors ka role to bahut hi significant hai. Legal aid lawyers, why? Because I want the High Court of Jharkhand to evolve a program wherein आपकी involvement और ज़्यादा बढ़ती है. दिल्ली में हमने legal aid lawyers को schedule roster बनाया है कि वो vulnerable witnesses को घर से court तक escort करते हैं in a court given vehicle. And we have fixed the rates per day. We have allocated the work to the legal aid lawyers so that they are also assured of a fixed source of income, which has been very, very encouraging. They perform the role of the facilitator for the witness. Now I come to the opening of my presentation, which is, you need to understand how this all began, how this project began. I was a lawyer from 1981 till 2004 when I was appointed a judge in the Delhi High Court. And during my lawyering, मैंने कोई case नहीं है जो नहीं किया. I have done murder trials also in this period as a lawyer. लेकिन एक तरीके की case थे which I did not want to. My conscience used to come in the way and I used to balk at the idea of doing a rape trial. I have never ever defended a person accused of rape. लेकिन as a judge you have no choice. आपको केस तो करना ही करना पड़ता है जो आपको चीफ जस्टिस, जो आपको डिस्ट्रिक्ट जज असाइन करता है. सो इन 2007 and 8 आई वाज असाइंड सिंगल जज का रोस्टर, क्रिमिनल अपील सुन रहे थे और एक लीगल एड का लॉयर जोर जोर से बोले कि जज साहब ये अपील तो आपको सुननी ही सुननी. क्यों? अप टू हियर दिस अपील. व्हाट वाज द अपील? It involved a complaint by a 7 or 8-year-old Tamil girl that a 19-year-old neighbor had raped her. And the man stood, that boy, young man, was convicted and he had already undergone 7 or 8 years of imprisonment by the time his appeal came before me. So I told still remember the lawyer's name, Mr. Dandapani, why are you insisting? The conviction rests on the statement of a 7-year-old girl child. You think I'll be able to disbelieve her? He says, I guarantee that you will acquit because there is not a iota of evidence. I began hearing the case. I'm referring to the provisions of law before the amendment. So section 161 ka bayan. Everybody in this room understands that. Is there anybody who doesn't? Engineers won't. But 161 का बयान इन्वेस्टिगेटिंग ऑफिसर जो पुलिसमैन होता है वो लिखता है जब कंप्लेंट आती है विक्टिम का बयान लिखा हुआ क्या लिखा हुआ था अक्यूज ने उस आदमी ने मुजरिम ने बुरी हरकतें की 164 का बयान सेक्शन 164 which is recorded by the magistrate during the investigation on oath but in the absence of the accused उसमें लिखा हुआ accused ने गलत काम किया The trial court judge, a seasoned sessions judge, a woman judge, had written something equally innocuous, sharamnak cheezein or something. Now, us time, the definition of rape required penetrative sexual assault. Am I right or wrong? So would anybody in this room convict on sharamnak harkate, buri harkate, galat kam? Lekin us time, it was presumed galat kam is rape. कि कोई जज में हिम्मत नहीं होती थी लिखने की तो क्या दिखता है इससे एंड मैंने आई ट्राई टू सर्च कि कुछ तो मिलेगा एविडेंस में जिस पे कन्विक्शन बेस की होगी तो देखा सेशंस जज ने एक क्वेश्चन पूछा था कि व्हाट डू यू मीन बाय दिस शरारतनाक चीजें एंड गलत काम दिस 7-year-old child या 8-year-old had said been recorded as having said what a husband and wife do at night कोई presumption है इन लॉ क्या What do a husband and wife do at night? Is there a presumption that they do one thing and only one thing? And the second thing was, it also depended on what the household was. अगर आप एक कमरे की नहीं हो रहा आवाज नहीं जा रही आवाज नहीं तो हम चेंज कर अगर वो नहीं वो you please confirm that the people are able to hear और जो ऑनलाइन ज्वाइन किया है push टीचर सुनाई दे रहा है नहीं तो एडजस्ट करिए प्लीज ring up and ask some officers ring up and ask the officers if they are able to hear
जी आवाज आ रही है
please raise your hand if you can't hear आप लोग जिन्होंने ऑनलाइन ज्वाइन किया है आप सुन पा रहे हैं सिर हिला दीजिए
यस मैम
Yes, we can hear.
Yes, ma'am. Yes, audible.
Yes, ma'am.
Able to hear.
Yes, ma'am. Yes.
So,
सुन पा रहे हैं
Yes, ma'am.
Yes, ma'am.
I was telling you, yes. So the session judge एक सवाल पूछ सकी थी
Good.
कि she had answered that husband and wife. So I said, did this judge bother to find out कि इस बच्चे को अगर एक छोटी सी झुग्गी में रहते हैं या in a hut, then you're able to maybe know what a husband and wife do at night if there's a presumption attached to what they do. And if they were living in a big house, if they were rich people and separate bedrooms and all, then no way could this child have known. I had to search the entire record from the child's father's statement, who was a petty driver. It came out that they were residents of a juggi and that the child's mother had abandoned them when the child was a few months old. So the household consisted of only the father and the daughter. So could this child have known? It was clearly a tutored statement of what a husband and wife do. Then I looked at the boy's defense. His defense was that that driver had borrowed money from him. And when he asked for its return of the money, he implicated him in this false case. A very plausible defense. The legal aid lawyer was right. I acquitted. लेकिन ये judgment लिखते हुए मैंने इतना law पढ़ा rape पे कि I found that the Supreme Court in Sakshi, in Gurdit Singh, host of judgments ने guidelines lay down की हुई थी कि रेप ट्रायल किसी सेक्सुअल वायलेंस केस में एफआईआर कैसे रिकॉर्ड होगी मेडिकल एग्जामिनेशन कैसे होगा कोर्ट ट्रायल क्या होगी यूज ऑफ स्क्रीन्स एंड ऑल दैट these were in different 6 or 8 judgments. I collated all these guidelines and this is what the judgment which I wrote was called Virender versus State. This case threw up these guidelines. उसके बाद हाई कोर्ट ने एक कमेटी अपॉइंट की लेकिन वीरेंद्र में क्या चीजें उभर के आती हैं आप खुद सोचिए क्या पता चलता है एक तो ये कि एक तमिल बच्ची दिल्ली में बयान दे रही है ट्रायल जज शायद बंगाल का है the 164 स्टेटमेंट मैजिस्ट्रेट रिकॉर्ड किए है वो शायद राजस्थान से आई है, और जो इंस्पेक्टर है जिसने या कांस्टेबल है जिसने इन्वेस्टिगेशन की है 161 का बयान वो हरियाणा का है। तीनों लीगली ट्रेन्ड हैं, है कि नहीं? देर ऑल लीगली ट्रेन्ड माइंड्स। सेशन जज इज सच एन एक्सपीरियंस जज। They are all reluctant to engage with matters involving sexual interludes. They were reluctant to get more intrusive and make a deeper inquiry to ensure that justice was done to a victim of rape. This shows that judges are a part of the social milieu. We all come from the same communities, we all come from the same educational backgrounds, yet we are reluctant to engage with matters involving the human body, especially sexual matters. Second thing, Tamil बच्चा, पता नहीं उसने क्या वर्ड्स यूज किए थे, उसको हिंदी आती भी थी कि नहीं, बुरी हरकतें, गलत काम, शर्मनाक चीजें, तो कुछ भी एक तमिल बच्चे की तो लैंग्वेज नहीं है. So language, the language that the person comes from can be a huge barrier to accessing justice for a victim of violence. So these things I highlighted, I noted, and I had written this opinion, Ajit. And I had written an opinion, wherein I had noted that the embarrassment and reservations which in the proceedings of the prosecutrix, witness, counsel may result in camouflage of the trauma of the witness, and they will cloud your judicial actions. I've requested the Judicial Academy to circulate this PPT. So I'll go over, we are short of time. We'll go to the next. Because of this judgment, the Delhi High Court Chief Justice, Justice A.P. Shah, appointed me as chairperson of the committee. उन्होंने मुझे appoint किया था not to frame this courtroom complex. He said, please ensure that the guidelines of the Supreme Court are worked. जितने भी cases में थे. As part of that, I undertook a global exercise. I looked at courts in Scandinavia. I looked at ये जो हमारा special project है, एशिया में और कहीं नहीं है, साउथ अमेरिका में भी नहीं है, अमेरिका में भी, यूएस में भी इन टर्म्स पे नहीं है, द कंफर्ट लेवल वी प्रोवाइड. इवन इन कनाडा आई हैव नॉट सीन इट. अफ्रीका में तो बिल्कुल नहीं है. कुछ कोर्ट्स ने इंप्लीमेंट किया है फैमिली कोर्ट्स में, लेकिन अब किया है, लेकिन 2012 में ये कहीं नहीं था. स्कैंडिनेविया में था ये, एंड वहां से मॉड्यूल लिया, इंटरैक्टेड विद ऑर्गेनाइजेशंस कॉल्ड फैमिलीज इन द कोर्ट इन कनाडा. देयर इज अ चाइल्ड विटनेस ऑर्गेनाइजेशन इन साउथ अफ्रीका. वो कश्मीर में आके उन्होंने मेरे लिए ट्रेनिंग भी करी है मेरे जजेस की. सो we identified this and did three things, this committee. Please bear in mind that I also not only had nothing to work from, no role model, no guidelines, I had no budget. This was a committee only to make sure trial courts में वो guidelines work करती है. So without a budget, what did we do? First of all, a Tamil child, इंडिया का कॉन्स्टिट्यूशन 28 भाषाएं रिकॉग्नाइज करता है, 16 लैंग्वेजेस. एंड आपको पता ही है आज की तारीख में लैंग्वेज कितना बड़ा मुद्दा है. लेकिन आप लोग के कोर्ट में भी कोई आ जाए, कोई हरियाणवी बोलते हुए या तमिल बोलते हुए या कन्नड़ बोलते हुए, तो आपको बहुत प्रॉब्लम हो जाएगी अगर उसे हिंदुस्तानी नहीं आती होगी या हिंदी नहीं आती होगी. तो फर्स्ट थिंग वी फ्रेम्ड वाज इंटरप्रेटर्स रूल्स. आपको interpreters चाहिएंगे not only in language, but suppose you have a blind person, उसकी identification को क्या कितनी weightage दी जाएगी, और you have a person जो बोल नहीं सकता, सुन नहीं सकता, a deaf person and a speech impaired person, उसका sign language में शायद वो बात कर सकता है, या कौन समझेगा वो signs से कैसे बोल रहा है, उसकी expertise आपको चाहिए. कोई मेंटली चैलेंज विक्टिम है या विटनेस है, उसकी गवाही को कैसे इंटरप्रेट करेंगे, कितनी इंपॉर्टेंस देंगे, इसके लिए आपको कोई मेंटल हेल्थ में ट्रेन इंसान चाहिए. तो हमने इंटरप्रेटर्स रूल्स बनाए थे, उसमें इंटरप्रेटर्स की फी बनाई थी. डिस्ट्रिक्ट जजेस को या हाईकोर्ट पे कमेटी अपॉइंट की थी डिस्ट्रिक्ट जजेस की, जो एम्पैनल करे किस किस को आप लोग हेल्प कर सकते हैं. दिस वाज टू हेल्प द ट्रायल कोर्ट्स. द सेकेंड थिंग वी डिड वाज वी फ्रेम्ड गाइडलाइंस. अब मैं कोर्ट रूम तो डिजाइन कर दे, लेकिन आपको पता ही नहीं कैसे यूज करना है, क्या कर सकते हैं आप, क्या नहीं कर सकते हैं. वेटिंग रूम में बिठा सकते हैं, वकील मिल सकते हैं कि नहीं, कैसे आप इंश्योर करें कि राइट्स ऑफ अक्यूज्ड कॉम्प्रोमाइज नहीं हो. ट्रायल हैज टू बी इन द प्रेजेंस ऑफ द अक्यूज्ड. व्हाट कैन यू डू? So we framed guidelines and we designed a vulnerable witness deposition complex using very, very simple technology. आगे बताएंगे आपको क्या किया था हमने। 16 सितंबर को 2012 को पहला कोर्ट रूम हमने डिजाइन करके इनॉग्रेट कर दिया था। एंड आपको याद होगा एक बहुत निर्भया का रेप केस हुआ था दिल्ली में, वो हुआ है 16 दिसंबर 2012। दिस वाज, इट्स नॉट माय प्रैक्टिस कि टॉम टॉम करूं, जगह जगह बताऊं कि क्या काम कर रहे हैं, लेकिन दिल्ली गॉट लेबल्ड एज द रेप कैपिटल ऑफ द वर्ल्ड। और किसी ने लेकिन ये नहीं सेंस किया कि दिल्ली में ऑलरेडी इतना सेंसिटिव सिस्टम वाज इन प्लेस टू लुक आफ्टर रेप विक्टिम्स months before that rape happened in Delhi. So this was the basis as to how this program came to be evolved. Now आपको ये समझना जरूरी है कि why do you need special facilities for vulnerable witnesses? You know, witness तो witness होता है, इनको special treatment क्यों दिया जाए? So इसके लिए I have a short clip. मेरे अपने यहाँ जजेस की ट्रेनिंग करी थी, 2 दिन की ट्रेनिंग थी, उसमें एक मेंटल हेल्थ एक्सपर्ट आते थे, अचल भगत। तो उन्होंने मेरी ट्रेनिंग्स में बहुत हेल्प किया। 2 दिन की ट्रेनिंग 10 बारी की, सारे एवरी सिंगल जज इन दिल्ली, एवरी सिंगल प्रोसिक्यूटर, पुलिस ऑफिसर्स अबव द लेवल ऑफ इंस्पेक्टर, लीगल एड लॉयर्स वी ट्रेन्ड। एंड अचल भगत का एक क्लिप है जो एक्सप्लेन दिखाता है ट्रेनिंग के दौरान का था कि क्यों स्पेशल फैसिलिटीज चाहिए होती है for a special class of witness. I will define vulnerable witness to you a little later, but vulnerable आप याद रखिए, we are talking of only the category of vulnerable witness, और क्यों उनको कोर्ट में जब वो हमारे पास आते हैं क्यों असिस्टेंस चाहिए। एक चीज और यह समझिएगा कि मैंने कोर्ट से क्यों शुरू किया। मैंने उस बच्ची को सुविधा 161 के बयान के स्टेज पे क्यों नहीं दी, इसीलिए नहीं दी क्योंकि मैं हर एक पुलिस स्टेशन नहीं जा सकती। बट इफ आई स्टार्ट फ्रॉम द कोर्ट रूम, इफ आई सेंसिटाइज माय कोर्ट रूम, इफ एवरी पर्सन हु कम्स टू माय कोर्ट रूम अंडरस्टैंड्स दैट द कोर्ट अंडरस्टैंड्स हिज पीड़ा, हिज पेन, देन ऑटोमेटिकली वो प्रोसिक्यूटर भी देखेगा, वो पुलिसमैन जो आता है, इन्वेस्टिगेटिंग ऑफिसर जो आता है, जो कोर्ट स्टाफ है, जो डिफेंस काउंसिल है, जो लीगल एड लॉयर है, सब sensitized होंगे. So my principle in life has been to begin top down. That's why I began with the most important spoke in the wheel of justice, which is judges, the court. Now please hear Achal Bhagat as to why you need a special facility for these vulnerable witnesses. Judicial systems are preoccupied with the presumption of innocence of accused persons. The needs and interests of witnesses are generally overlooked, even though they are considered the eyes and ears of the courts. The situation is worse if the witness is a victim of sexual violence. What is the impact of testifying in court by a victim of sexual violence? Does it have any effect? On this aspect, let us hear Dr. Achal Bhagat, a mental health expert in Delhi, who helped conceptualize and set up the vulnerable witness deposition complexes, as well as was a valuable resource person in the trainings conducted in Delhi between 2012 and 2017.
It is important to remember that a vulnerable witness may be re-traumatized during the judicial process. So the person needs to be protected so that they are not re-traumatized. Why should the person not be allowed to be re-traumatized? Because re-trauma means that the person relives the experience of violence. So it affects them psychologically. It causes them extreme anxiety. It may make them numb. It may make them not remember things accurately. What might cause re-traumatization? Any reminders that the person might get of the past when they were traumatized through the cues in the judicial process. And these cues could be simple. These cues could be the voice of the alleged perpetrator, the color of the shirt of the alleged perpetrator, the smells around the process, the way the questions are asked. The person might be pushed back into the same experience of trauma, and they might relive the trauma as if it was happening to them just right then during the judicial process. Now, one, it is not helpful for the judicial process to re-traumatize somebody. The very fact of re-traumatization means that the person is being harmed and it may cause disability. Two, it causes a lack of substantive equality in the process, because if the person is compromised because of their anxiety, because of their numbness, because of their inaccuracy in the memory, the judicial process itself is compromised because it's not equal in the same way. So the access to justice becomes an issue. Re-traumatization is not only for preventing psychological disturbance to the vulnerable witness, it is for ensuring access to justice.
Can I make one suggestion to the director? If you can ask these people to keep the water on the side, anybody who needs water can get up and take, rather than the person walking around in the middle. साइड में रखवा दीजिए, जिससे ये अपने आप सब ले सकते हैं. टेबल पे ही रख दे, सामने टेबल है. Anybody who wants, please get up and take the water. It's right here. That's the practice whenever we do conferences all over the world, we get up and help ourselves, even when we are judges. So this was a short bite from Dr. Achal Bhagat, so I think you all could hear him. You could understand that revisiting the trauma. I'll relate a small story to you, as to what is the impact of having to recount an experience of violence. Justice Pradeep Nandajog was a very dear brother of mine in the Delhi High Court, and we had gone to the Delhi Judicial Academy, and during his program, he was doing a similar lecture. He told the director to distribute small pieces of paper to every person in the room, and we gave them pencils, and he told these judges, they were session judges, all of them, that please write on this piece of paper, don't give your name, change your handwriting so that it can't be recognized, it can't be identified whose paper it is. Write down the most pleasurable time you have spent with anybody in your life, your partner, your husband, your spouse, your wife, anything. Just write the most pleasurable moment in your life, and we will see it after 10 minutes. When the papers were collected after 10 minutes and they were opened, there was not even a full stop on any piece of paper. People could not even bring themselves, the judges could not bring themselves to even write about pleasurable times spent with their husband, wife, partner, friend, whatever. Such is the reserve in having to share a pleasurable moment. Can you think of a witness, a person who has undergone a rape and has to recount that in court? So please remember that revisiting that same incident by itself, firstly coming to court. When I began as a lawyer, and my senior was left, we had to go out of station, and she told me to go to Justice B.N. Kirpal, was a single judge at that time, talking of 1981. She said, go and take an adjournment from him. He had become a judge of the High Court only in 1979, but he was a very firm judge. My knees were shaking, my shoulders were shaking. I rehearsed the 7-8 words which are uttered. May I have your lordship's indulgence and seek 1 week's adjournment. My senior is in personal difficulty. ये वर्ड्स मैंने शीशे के सामने खड़े होके कितनी बारी प्रैक्टिस किए, and then I took everybody I knew, all my classmates from law faculty, I took them with me to the courtroom कि बहुत डर लग रहा है, to just utter these words. आप उस इंसान की सोचिए जिसको लॉ नहीं आता, जो लॉयर नहीं है, लेकिन एक बहुत ही humiliating, degrading, fearful experience undergone करके आपके सामने कोर्ट में पेश होता है, उसकी क्या हालत होती. So this is the reason that we must be very sensitive to these vulnerable witnesses. Now, we had a definition of vulnerable witnesses in the guidelines, and on the suggestion of the committee, the Supreme Court has expanded these to several categories. They are on the screen. हमने तो child witness per se, whenever a child has to testify, वो vulnerable है. Any victim, male, woman, female, boy of a sexual violence, age neutral victim of sexual violence, gender neutral victims of sexual assault, age and gender neutral victims of section. Please see that the original order of the Supreme Court may sections are of the original IPC and CRPC. In the bullets at the bottom, you will see the new sections. Then, next slide, please. The witness is suffering from mental illness. Any witness to have a threat perception. For instance, a husband and a wife, a jeweler come out of the house. He is going to his shop. Dacoits come. They attack the jeweler to snatch away his briefcase, which has money and jewelry. And in the wife's presence, he is killed, shot dead by them. They run away. In the trial, this wife would be petrified. She is witness to a very dangerous crime. So she may be under threat from them. So, or in a case of kidnapping, the victim or witness who is giving evidence against the kidnappers, then any speech or hearing impaired person. And the last category which the Supreme Court has evolved, as noted in Stuti Ram, is the discretion to each one of you who is a judge here. Any other witness deemed to be vulnerable by the concerned court. So you have full discretion to evaluate your cases. So when you go back to your courtroom now, get an audit undertaken by your LMATs. You call them LMATs, yeah? The supervisor जो कोर्ट के साथ associate trial coach. नहीं, पेज गार्ड नहीं, जो LMAT फाइलें हैंडल करते हैं, फाइल रखते हैं.
ऑफिस
क्या बोलते हैं?
ऑफिस क्लर्क.
नहीं, जो ऑफिस में फाइलें, जो प्रोसेस कॉमन बनाते हैं, क्या बोलते हैं उनको?
ऑफिस क्लर्क.
क्लर्क. अच्छा, हम लोग हेलमत बोलते हैं. तो उनसे कहिएगा हर एक केस में, प्रोसिक्यूटर को बोलिए कि हर एक केस की ऑडिट ले. दिस इज द फर्स्ट स्टेप टू दिस प्रोग्राम, फाइंडिंग आउट विच केस हैज अ वल्नरेबल विटनेस, और उसको ऊपर केस को मार्क करिएगा. जहाँ पे वल्नरेबल विटनेस फैसिलिटीज बन गई हैं, वहां पे तो आप ट्रायल पीरियड कर सकते हैं, शुरू करा सकते हैं. लेकिन जहाँ पे नहीं गई है, वहां पे फर्स्ट स्टेप इज टू मेक एन ऑडिट. नेक्स्ट स्लाइड. देन क्रिमिनल, सिर्फ क्रिमिनल केस नहीं है जहाँ वल्नरेबल विटनेस होते हैं. बच्चे तो बहुत मासूम होते हैं, दे आर वल्नरेबल एंड दे विल बी inevitably be in a child custody case, the juvenile justice boards, in a maybe in a testamentary case, in a case of domestic violence. So vulnerable witness can be in several cases. So I had submitted a report to the Supreme Court, which saw my program, and in January 2021 appointed me as this committee to run the program pan-India and do these trainings. So I had suggested to the Supreme Court, and they have accepted the suggestion given by the court, by the committee, and expanded this to be available to other judges. Even in a civil court, you have a vulnerable witness, disabled witness, use this special facility. Next. So till now, what have we noted? That the legal systems are adversarial, and this is very problematic for vulnerable witnesses. And definitely, Criminal Procedure Code, Civil Procedure Code, it does not discriminate, does not differentiate between different categories of witnesses or cases. Same universally applied procedure and norms are prescribed for witnesses of all kinds. Then children ke baare mein, there's a special problem. Children may be the only material witnesses in cases of child sexual abuse. This kind of violence happens in the secret. Abuse by tutors, abuse by teachers, abuse by a bus driver, abuse by a school chowkidar. So they may be the only witness. And secondly, children would be also witnesses, very important witnesses in cases involving domestic violence and crimes. Please be cognizant that children, Ajit. So, children are unique. This is a child's reaction when they came to court and they saw black and white. Who else is in black and white? Why is everyone dressed like a penguin, black and white? What similarity hai dono pictures mein. This is an aside on a lighter side. This was the reaction of a child witness who came to court and said, why is everyone dressed like a penguin? Please remember a couple of things. That children don't give evidence in one go. They give evidence in bits and pieces. And there's several reasons why they cannot give evidence completely, proper account. One is multiple interviews. Interview का मतलब हुआ 161, 164 trial court. Then कितनी wait होती है between lodging of an FIR, filing of the charge sheet and the coming up of the trial. Then विटनेस की एविडेंस की स्टेज आ गई, लेकिन जज साहब के पास टाइम ही नहीं है. उनकी वल्नरेबल विटनेस के केस से पहले वाला मर्डर ट्रायल बहुत भयंकर है, बहुत लड़ाई चल रही है, बहुत अक्यूज्ड है, कोई गैंगरेप का मसला फंस गया पहले, तो केस अर्जन होता है कई बारी. फिर कन्फ्रंटिंग द अक्यूज्ड, ये तो आपको बताया, डॉक्टर भगत ने ही बताया कि आप अक्यूज के सामने पेश के साथ खड़े होके, हमारी कोर्ट रूम की क्या सुविधा है, व्हाट इज द कोर्ट रूम स्ट्रक्चर लाइक. एक जज साहब का डायस है, फिर एक टेबल है, एक तरफ अक्यूज खड़ा है, एक तरफ डिफेंस खड़ी है, बीच में प्रोसिक्यूटर है. गवाही देनी है तो विटनेस को बीच में ले आते हैं, तो विटनेस और अक्यूज कंधा कंधा मिला के आए खड़े हैं. अगर अक्यूज और विटनेस नेबर्स हैं, पड़ोसी हैं, तो शायद सेम बस में आए हैं, सेम टेम्पो में बैठकर कोर्ट आए हैं. कोर्ट के बाहर वेट करने की तो जगह है नहीं, विटनेस के लिए तो हम कमरा ही नहीं कोई बनाते. तो अक्यूज और विटनेस शाम के 3 बजे तक, जब तक केस कॉल नहीं होता, सेम बेंच पे ही बैठे हुए हैं. तो कितना, और अक्यूज के साथ तो 10-10 रिश्तेदार आते हैं, विटनेस बेचारा अकेला होगा या एक जना कोई साथ होगा. कितनी डिमोरलाइजेशन होती है, कितना कॉन्फिडेंस लॉस होता है विटनेस का. सो दीज आर ऑल प्रॉब्लम्स ऑफ कन्फ्रंटिंग द अक्यूज्ड. एंड देन टू टॉक अबाउट रेप, against give evidence of a rape standing shoulder to shoulder with the accused, and then language of the questions. डिफेंस काउंसिल तो कवर करेगा कि उसने तो पकड़ना है उसको, विटनेस को. देन ऑनेस्ट आंसर बाय द विटनेस. विटनेस कहता है मुझको थोड़ा सा सोचना पड़ेगा जज साहब. अक्यूज का लॉयर एकदम से जोर जोर से चिल्लाने लगेगा, देखिए इसको तो याद ही नहीं है, ये तो गलत है, गवाही अपनी सोच के दे रहा है, कुछ कहानी बना के दे रहा है. Next, please. Then all kinds of things. Then हमारी बड़ी आदत है, कॉम्पिटेंसी टेस्ट करते हैं आप बच्चे की, तो आप उससे पूछते हैं कि तुम्हें सच और झूठ का अंतर पता है. अब ये कोई सवाल है पूछने का, और बच्चा क्या जवाब देगा. देन लॉयर्स की इंटरप्शंस. 3 केस है मिलते जुलते, ओवरलैपिंग है, वो बच्चा या कोई वल्नरेबल विटनेस गवाही दे रहा है, एक केस में दूसरे केस का रेफरेंस देना जरूरी है. कितना शोर मचाएगा डिफेंस लॉयर कि ये तो इररिलेवेंट है. और शोर इसलिए नहीं मचाएगा क्योंकि इररिलेवेंट है, शोर इसलिए मचाएगा विटनेस घबरा जाए, विटनेस दब जाए, विटनेस डिस्ट्रैक्ट हो जाए. फिर सवाल पूछा जिसका आंसर जवाब लंबा है, लेकिन वो वकील कहेगा आप हाँ या ना में जवाब दीजिए और एक वर्ड नहीं बोल सकते. तो यहाँ पे जज का रोल बहुत इंपॉर्टेंट है. यू हैव टू इंटरवीन एंड एंश्योर दैट जस्टिस इज डन टू द विटनेस, to the witness, to the case. Real justice, substantial justice should be done in your courtrooms, Then cross-examination to catch the witness out. फिर admissibility पे कोई document prove कर रहा है witness, उस पे इतनी लंबी बहस होगी, इतनी लंबी बहस होगी कि बच्चा ही भूल जाएगा, witness ही भूल जाएगा, कोई लेडी है, कोई mentally challenged person है, बिल्कुल भूल जाएगा, कोई context ही नहीं रहेगा. तो बिल्कुल गवाही जो useless है बिल्कुल केस के लिए, वो आपके सामने आएगी. तो आप लोग को बहुत विजिलेंट रहना है अपने कोर्ट में कि आप इंश्योर करें कि एक विटनेस को ठीक प्रोटेक्शन दे. इंश्योर दैट द विटनेस इज एबल टू हेल्प यू इन रेंडरिंग जस्टिस. नीचे एक चाइल्ड विटनेस की स्टेटमेंट है. तो ये बात मैं नहीं कह रही, ये मैंने सीखी है. मैंने तो कभी क्रिमिनल सेक्सुअल वायलेंस का केस किया ही नहीं था, लेकिन एक्सपीरियंस, तजुर्बे से हमने सीखा है, पढ़ के सीखा है कि एक कोर्टरूम की environment is and the complicated legal procedure is absolutely terrifying for a witness. And then confrontation, standing shoulder to shoulder with the accused person and having to recount and repeat the humiliating, the torturing, the traumatizing experience, facing aggressive and humiliating cross-examination results in what is a legal expression almost today, secondary traumatization of the witness. It is very, very disabling. And as Dr. Bhagat said, you have prevented equal access to justice. You have prevented equality to the witness, to a victim, to seek justice equally as the protection that you have given an accused person. Next, Ajit. So with these thoughts in mind, we have designed the vulnerable witness courtroom. Now, I want to ask you one thing. Next, please. Next, please. This is the, please remember this is a child. And the children are not miniature adults who can morph suddenly into adults when they come to the court. They remain children. टुकड़ों में बच्चा गवाही देता है. आपको हाई कोर्ट से बार बार डायरेक्ट किया सर वो आता है आपकी कोर्ट रूम में तो बिना उसकी गवाही रिकॉर्ड किए मत भेजिएगा. लेकिन ये कई बार गलती हो सकती है, बहुत बड़ी गलती. प्लीज सी द विटनेस, assess the witness's ability. पहली बार ही उसको let him get used to the court. उससे बात करिएगा, उसको समझाइएगा क्या प्रोसेस आप फॉलो कर रहे हैं, वो क्यों कोर्ट में आया है. और आपको लगता है कि उसको थोड़ा टाइम चाहिए, adjourn करिएगा केस. लेकिन adjourn करते हुए प्लीज रिमेंबर few very important things. One is बच्चे स्कूल जाते हैं, उनके पेरेंट्स कैन बी लेबरर्स जो डेली वेजर्स होंगे. तो दोनों की नीड्स को देखते हुए ऐसा टाइम नियुक्त करिएगा, फिक्स सच अ टाइम that the child's education is not hampered and the parents' wages are not lost. Fix it at 4 o'clock on a Saturday, the case. Or even later if you can, sit later, but ensure that you do complete justice. Please ignore anybody else's grievance. Prosecutor will say, घर जाना है. Investigating officer will say, मेरे को एक और केस में charge-sheet पूरी करनी है. Don't let that influence in ensuring justice to a victim or a witness who is covered under the definition of vulnerable witnesses by any stretch. Please look into the special needs of these witnesses. Now I'll share, I want to tell you one thing more which is very often shared, that in India we hear this and it's also maybe a part of many judgments. Delhi mein to we have Mahila courts. I don't know if you have them here. Mahila courts to look into cases involving domestic violence and other cases involving women. Yours? Yes. So un courts mein we are posting only women. And male judges really resent this. So they resent trainings on gender also. They feel they are treated, they are not required to do or attend to anything like this. I'll tell you a short story which experience which was related by Chief Justice Beverley McLachlan. She was the Chief Justice of the Canadian Supreme Court for the longest time. वो trial court से Canada की Supreme Court बनी, Chief Justice बनी, lifelong रह सकती थी, but she resigned. वो बताती हैं कि जब वो ट्रायल कोर्ट पे थी तो ये ऐसा हुआ कि एक मुजरिम को पुलिस ऑफिसर अंदर कोर्ट में लेकर आई. जो ही द डिफेंडेंट, दैट ऑफेंडर, दे कॉल देम डिफेंडेंट देयर, accused was brought into the courtroom, he started trembling. वो कांपने लगा. तो जज साहब बड़ी परेशान, इधर उधर देखा कि कांप क्यों रहा है, अभी तो केस शुरू भी नहीं किया. तो उन्होंने उस ऑफेंडर से पूछा कि तुम अभी तो केस शुरू भी नहीं किया, why are you trembling? He said, Judge, look around you. I'm completely outnumbered. So, she looked around the room and then she realized why he was saying he's outnumbered. वो तो एक मेल था. जो पुलिस ऑफिसर लेकर आई वो एक वुमन इंस्पेक्टर थी. जो प्रोसिक्यूटर थी वो एक लेडी थी. जो जज साहब थी वो तो महिला थी. जो जज साहब का स्टाफ था वो भी सिर्फ चांस की बात है, ये महिला था. And as luck would have it, his own lawyer was a woman. So he said, I feel completely outnumbered and overwhelmed. And he didn't think he'll get justice from a room of women where he's the only male. So please put yourself in the shoes of all those women, who have suffered an act of rape or sexual violence or domestic violence and are expected to come into rooms full of men. The number of women in the judiciary is still less, though many at the lower levels we're almost 50% in some states in the lower judiciary, in the trial courts at the bottom level. But as we go higher, the number of women get reduced. But put yourself in the shoes of these women who have to appear in room full of men and give evidence. So when the High Court says we will assign these kind of cases to women, it's not because male judges are not competent. It's not because they are not sensitive, but it is only to keep to the provide for the sensibilities of the women victims, the women witnesses. Please bear that in mind and don't feel bad. The one question to anybody in the audience, even on the who have joined online, you can raise your hand. आप लोग सब ट्रायल कोर्ट में ट्रायल्स कर रहे हैं. Can anybody here tell me of whether law as it existed provided for any special measures? Law provided any special measures for the victims, for vulnerable witnesses? कुछ भी provision था existing law में या पुराने law में, कुछ भी आप कर सकते थे to make their experience in court a little comfortable. Anybody's raised their hand? Can anybody in this room tell me? I'm told there are district judges here. आपको समझ नहीं आया कि जो कानून है उसमें कोई भी सुविधा है, कोई भी प्राविधान है कि कोई चीज आप कर सकते हैं? समझ आया है सबको? इट्स अ वेरी सिंपल क्वेश्चन. For a victim of rape, anybody online, raise your hand. Yeah, please speak up. Please stand up. What's your name?
Ma'am, my name is Siddharth Singh. I'm additional public prosecutor
Just
from.
1 minute. 1 minute. 1 minute. आप बोलिए.
माय नेम इज अनिल कुमार सिंह. मैं यहाँ पब्लिक प्रोसिक्यूटर हूँ रांची कोर्ट में. इन कैमरा ट्रायल का प्रोविजंस है पहले से.
I see. Very good. कौन सा सेक्शन था और कौन सा है?
एक्चुअली मैं ऑफेंसेस अगेंस्ट वुमेन्स नहीं देखा, जजमेंट्स में पढ़ा था और डायरेक्शन की इन कैमरा वो कोर्ट देखेंगे और विटनेसेस अगर आते हैं रेप के केसेस में, जनरली मैंने 1-2 केसेस में कैमरा ट्रायल किया है.
Very good. Very nice. Somebody else was speaking? Please raise your hand. Somebody online?
Ma'am, my name, ma'am, good afternoon.
Siddharth Singh.
Yeah, Siddharth
Please
Singh.
video on करिए.
Ma'am,
आप कहाँ पर posted है और क्या करते हैं?
from Ranchi. Ma'am, the provision regarding the trial is in camera trial, and the same is also provided in POSCO Act. Ma'am, I don't go through the POSCO cases, but there is a provision for in camera trial, and in our Ranchi civil court, the camera trial is functioning very properly.
Very good. So that is now what happens in a camera trial. आप बताएंगे क्या करते हैं आप जब camera trial order करते हैं, सिद्धार्थ?
Ma'am, in camera trial, environment has been created for the child witnesses, where they are before deposing the evidence, they are given a comfortable environment. And secondly, there is only a female prosecutor there, where she gets in an interview with the concerned victim, and thereafter there is a VC in the room, and where the statement of the witness is to be recorded. Ma'am, I haven't done a in-camera trial of a victim, but I know I have from different judgments and from the guidelines I have acquired this knowledge.
All right. Thank you, Siddharth. आप mic off कर सकते हैं आप.
Thank you.
So camera trial enables you to remove everybody from the courtroom जो उस case में relevant नहीं है. So you will have the accused person, you will have the defense lawyer, you will have the prosecutor, you will have the judge, and you will have the court staff, and you will have the investigating officer. But is this enough? Does this work justice to the victim? इसके बारे में I will share with you a short video of a victim of gang rape. उनका नाम था सुजेट जॉर्डन. एक कोलकाता में रेप हुआ था, पार्क स्ट्रीट गैंग रेप. बहुत उसको almost the same level of publicity which निर्भया वाला received. And Suzette Jordan, एक 35 साल, 35-year-old mother, single mother थी. She was separated from her husband. She had 2 grown-up daughters. She had gone to a restaurant or a bar and was returning home from there when some neighbor offered to give her a lift. And उन्होंने वो lift ले ली. Lift तो क्या दी? Her life changed after that because she was subjected to gang rape by a group, by that group of people who gave her the lift. She went through extreme trauma. The chief minister said ये political trial है, political case है. It is to embarrass the government. उसको लैंडलॉर्ड ने घर से निकाल दिया, उनको जॉब से खत्म हो गया, उनको एफआईआर लिखाने में रात के 2 बज गए, 3 बज गए, बहुत देर तक जितने लोग पुलिस स्टेशन में आए वो बार बार सब पूछे क्या हुआ केस में, लेकिन मैं वो सब आपके साथ शेयर नहीं करी. इतनी ह्यूमिलिएशन फेस की सुजैत जॉर्डन ने that she decided that she will not conceal her identity. She started speaking up for rape victims. And she came to Delhi in the trainings which I did. And इधर मैंने जितना उनका कोर्टरूम एक्सपीरियंस था वो आपके लिए क्लिप निकाला है. हमने उनसे डिस्क्लेमर लिया था, परमिशन ली थी कि हम यूज कर सके उनका क्लिप. अनफॉर्चुनेटली 5 में से 3 पीपल वेंट टू ट्रायल. उनको 10-10 साल की सजा हो गई सुजैत की एविडेंस के बाद. उसके बाद शी सफर्ड मेनिंजाइटिस एंड शी पास्ड अवे. तो जो दो absconders थे वो were scot free because Suzette wasn't there to testify against him. लेकिन कैमरा ट्रायल, whether it works, justice or not, आप मेरे शब्दों की बजाय आप सुजैत जॉर्डन क्या बयान करती हैं आप ये सुनिए.
In the courtroom, the complainant will always be one, or maybe two women. But if it's a gang rape, there'll be like, if it's 5 or 6 guys in a gang rape, then there are 6 lawyers. And their 6 lawyers have 6 assistants. And their 6 assistants have junior assistants. But the complainant has just 2 lawyers, max 3. 2 de factos, a public prosecutor. The very fact that she has to go in there, it's an in-camera trial. It has its advantages. It has its disadvantages as well. The advantage is it keeps you protected from public and more humiliation from the prejudiced, patriarchal kind of people. But the disadvantages is the victim has nobody inside the courtroom except her public prosecutor, who's really not her family friend. She's a professional doing her job. So it should not be the victim, because even in my case, I was told I could put a petition if I wanted somebody to be a support for me inside the courtroom. But there are thousands of girls, little girls, who are being raped, who are in the courtroom, and they don't know that they can avail of that facility. So no one will tell them, because I was told this. If I was told this, that if I get a lawyer, then I have to put a petition, the case gets prolonged, dates keep changing. Nobody wants that. So they don't even know that. So this order should come from the court. This facility should be given to the victim. Would you like a support system? Would you like your mother? Would you like your father? Would you like an extra person in that in-camera trial so that you feel safe? You expect a victim to stand there, having the accused, and then to narrate her ordeal, and then be questioned and re-questioned. That, firstly, a rape is the murder of the soul. All these re-rapes completely murder the very mind, the little sanity that the victim has left.
I wish I could share with you the rest of Suzette's experience, from lodging the FIR. It was so bad. A medical examination was conducted in a room which had glass windows. Calcutta has old buildings, glass windows, and there was a boys' hostel across the road. So she discloses how she was made to take off her clothes and stand with her hand outstretched while the doctor did the examination in this kind of an environment. She was really heartbreaking, and her revelations were astounding and extremely hurtful. But this is a short experience of this is a true, it's not a story. It's a true experience of what it is to be a victim of rape in the courtroom. We standing in the same room as the accused person and having to relate what she has undergone. So as a consequence, at the opening, I told you we had framed guidelines, but I'll come back. I won't stop. These guidelines enable you to have a pre-trial visit. If the witness needs help, the investigating officer can bring the witness earlier to the courtroom, and the judge can explain the process to the victim and what will happen and why she is needed. It enables you a lot of aids and assistance, and many things are provided. So, and the next slide, please. These guidelines have drawn from legislations and guidelines from all over the world. They're best practices from across the globe. They're linked to international conventions. They provide for the victim to have a witness to have a support person, a facilitator, a guardian ad litem, legal aid, pre-trial visit, and interaction with judge and prosecutor. Concealment of witness identity, developmentally appropriate questioning, and then most important, if a witness is provided these special facilities, can the accused say, draw an adverse inference against the witness? The answer is no. The guidelines specifically provide for this. And the biggest thing is that I had shown these guidelines to lawyers and judges in the United Kingdom, because UK is very strong on ensuring rights of every person. And they had suggested that if we made this facility available not only to witnesses of the prosecutor, but we said that even a vulnerable witness who's appearing for the accused is provided the same facility, then there would be no objection. So there can be no objection. So the guidelines enable this. Now, so far as these guidelines are concerned, the Jharkhand High Court had adopted the guidelines which we had circulated, which are the seal of approval by the Supreme Court of India. But the criminal law changed, and the provisions of laws which were mentioned in the original guidelines, which have been notified by the High Court of Jharkhand, changed. We circulated, changed this. I know, I was told it's pending with the full court. Acha, ho gaya. Acha, okay. So now you must, so I'll request the committee, Brother Anando, to organize a training where we'll do just the guidelines for only the judges and the prosecutors and the lawyers. It can be an online training. Any of you can join whenever. Now, coming to the concept of the VWDC. This is what you must remember. Please keep in mind, this is where children are concerned, but the same thing applies to adult vulnerable witnesses. Language of the witness, memory of the witness, temperament, disposition of the witness, cultural context. Koi parda nashi lady hai, uska experience different hoga from somebody coming from a metropolitan city, and the environment while asking us for information. Next. So the concept of the vulnerable witness courtroom, it's not some rocket science. It's not been conceptualized by the legislation. It's not been conceptualized by the Supreme Court, but a small committee of the Delhi High Court, which had no experience in this field. And it's pure research and the assistance of some of the district judges and lawyers, not only in Delhi, and academicians. I have used people who work on the ground. Tuli is an organization which works with children, victims of sexual violence in Chennai. I have worked with child witnesses in South Africa. I have worked with Professor Jagdish Reddy from Bangalore, a forensic science expert. I've used Padma Deostali and other social scientists from Mumbai. I've used Professor Mrinal Satish and Aparna from Bangalore National Law University. There are several experts in Delhi. I've had the wisdom of transgenders, from people from the LGBT community, from sex workers, assisting me in conceptualizing these guidelines and the courtroom. And it's a pure case of judicial initiative and judicial intervention. Why I am saying this is that it is to empower you and enable you to take steps, take initiatives of your own accord, craft out manners in which you will be able to ensure that the justice delivery system is more humane. Don't get bogged down by just finishing your units and completing cases just to ensure that your ACR is not downgraded. Do real justice. Work hard, work honestly, work with humility, and you will see that the units will flow automatically. Please be very, very careful in your courtroom. My daily prayer for the 16 or 18 years that I was a judge was not that I should do the maximum disposal. There are many judges who tom how many cases they have disposed of. My daily prayer was, God, let no one leave my courtroom with a sense that he or she has not been heard. And not being heard, not being heard is also for witnesses. It is also for the person or the litigant who comes to your court in person, who doesn't have the money. Ensure and create level playing fields. एक बहुत अमीर हस्बैंड है और वो वाइफ की मेंटेनेंस एप्लीकेशन डिसमिस करने के लिए टॉप मोस्ट लॉयर रांची का एंगेज करके लेकर आता है कहीं गुमला विलेज गुमला डिस्ट्रिक्ट गुमला के किसी छोटे गांव में, तो आप क्या करेंगे? योर फर्स्ट स्टेप विल बी नॉट टू डिसाइड द सेक्शन 24. फर्स्ट स्टेप इज टू इंश्योर एंड क्रिएट अ लेवल प्लेइंग फील्ड. Ensure that the lady gets equal legal assistance. Look for the best legal aid lawyer. आप खुद पढ़िए और कानून बताइए उस opposite lawyer को, husband के वकील को कि ये judgments आपके खिलाफ है, meet these, so that he is also not prejudiced. But ensure level playing fields to every litigant, every witness, even your court staff, and ensure that you are rendering real justice. Don't just ride roughshod over your cases. It is very, very critical. So what was this vulnerable witness deposition complex intended to do? It was to ensure substantive justice. It was to ensure sensibilities and the trauma of a victim. She or he is not re-traumatized. And how did we do it? We prevented an interface of the witness with the accused, as well as no public exposure of the witness. वो witness court आता है, court complex आता है, लेकिन there is no meeting, this is for the engineers, with any other lawyer, with any other member of the public. Entrance be separate hai. And the second is that we used a video link and an intermediary to avoid a physical confrontation between the accused and the witness. Now I'll show you a short film. This is for my request for the engineer friends here. कि इसको आप देखिएगा कि बिना बजट के आप जो फर्नीचर देखेंगे वो मैंने सारे डिस्ट्रिक्ट जजेस को बुलाया. जब डिजाइन बना लिया, सोच लिया क्या करना है, तो दिल्ली के 7 डिस्ट्रिक्ट कोर्ट्स के डिस्ट्रिक्ट जजेस को बुलाया एंड सेड आई नीड 1 कोर्ट रूम जिसके साथ अटैच जजेस चेंबर है, और अगर अहमद का कमरा मिल जाता है ठीक है, नहीं मिलता तो भी ठीक है. तो they all laughed at me. 2012 में तो they thought I am crazy, I'm mad. You know, what is she trying to do? One district judge gave me 1 courtroom in Karkadova district court, and वो हमने craft किया. कोई बजट नहीं था, एक पैसे की allocation नहीं थी, ना हाई कोर्ट की ना डिस्ट्रिक्ट कोर्ट की. पुराना फर्नीचर स्टोर में जाके निकाला, ह्यूज ऐसे, ये तो छोटे सोफा है जो आप देखेंगे फिल्म में, इनको रिफर्बिश किया सिर्फ थोड़ा कलर चेंज करने के लिए. जो फर्नीचर अवेलेबल था, जो LCD अवेलेबल थी, जो लैपटॉप अवेलेबल था, जो माइक अवेलेबल था, जो माइक्रोफोन अवेलेबल था, जो स्पीकर अवेलेबल था, उससे देखिएगा हमने क्या क्रिएट किया.
The vulnerable witness deposition complex is an instance of judicial initiative and judicial intervention. It has been conceptualized to prevent secondary traumatization of vulnerable witnesses. The major difficulty being faced in creating the vulnerable witness deposition complexes relates to non-availability of resources, finding land and finances to raise new complexes is a challenge by itself. For this reason, in Delhi, all such complexes have been crafted and developed by making minor modifications to existing codes and use of simple technology tools. All that is needed is a separate judge's entrance, a courtroom, its attached judge's chamber, an adjacent Ahmad's room or administrative staff room, some space hived even from a corridor for making a waiting room, a small toilet, and a small pantry area is sufficient. To illustrate, the following video leads us through the vulnerable witness deposition complex, which was inaugurated on the 16th of September 2012 in the Karkaduma Court Complex, Delhi. The complex allows for a separate entrance for
What you're seeing is the judge's entrance to the court complex. I presume यहाँ भी अलग ही होता होगा. So judge's entrance we have shared for entry for the vulnerable witness. वो लेफ्ट साइड में पहले जो था और राइट साइड में कवरिंग वगैरह करके ये बाद में बनाया गया, रैंप पूरा किया गया कि कोई विटनेस डिसेबल्ड है उसके लिए.
the vulnerable witnesses through the judge's entrance, corridor, and elevator. This reduces the insight
फ्रॉम द एंट्रेंस आप लिफ्ट पर आते हैं. ये कमरा 6th फ्लोर पर है. इधर मैं आपको एक्सप्लेन कर देती हूँ. लिफ्ट से निकले तो आपको सामने कॉरिडोर में दिख रहा है, एंड ऑफ द रूम एक दरवाजा दिख रहा है. इधर जस्ट बिफोर द दरवाजा राइट साइड पे कोर्ट है, लेफ्ट साइड पे जज का चेंबर है. तो जो जज का चेंबर था उसको भी कन्वर्टेड इनटू द यूज ऑफ द रूम फॉर रिकॉर्डिंग पुटिंग द विटनेस. एंड जो सामने आपको दिख रहा है एंड पे भी एक दरवाजा है, बिल्कुल एट द एंड ऑफ द स्लाइड. दैट दरवाजा वाज टेम्परेली पुट ऑन द इन द कॉरिडोर. वेटिंग एरिया हमने कॉरिडोर में से क्रिएट किया और एक छोटा सा टॉयलेट बनाया वेटिंग एरिया का, अभी आपको दिखाएंगे. बट इससे कंप्लीट प्रिवेसी मिल जाती है, सेग्रीगेशन मिल जाती है वल्नरेबल विटनेस.
and shields the witnesses from contact with the accused, other litigants, lawyers, and the general public. A waiting room, pantry.
ये था लेफ्ट साइड में देखिएगा जो कॉरिडोर है, लेफ्ट साइड में देखिएगा ये कॉरिडोर है. इधर हमने जो शीशे दिख रहे हैं आपको, उससे पहले थोड़ा ये हमने दरवाजा लगाया, दीवार बना के, और उसी दरवाजे के साइड में छोटा सा टॉयलेट है, आपको आगे दिखाते हैं. डॉक्टर अचल भगत हैज हेल्प मी डिजाइन दिस कोर्टरूम. उन्होंने कहा था कि बच्चे आर वेरी प्रोन टू सजेशन, तो फोटोज मत लगाइए. तो दीवार को अपने पेस्टल शेड से कलर किया है, कोई फोटोज कोई पिक्चर्स नहीं है इस कमरे में. आप फर्नीचर देख रहे हैं, जो मैंने आपको बताया पुराना फर्नीचर है. डिफरेंट एज ग्रुप्स की डिफरेंट सीटिंग रिक्वायरमेंट्स होती हैं. छोटा बच्चा मेज कुर्सी पे सोफे पे नहीं बैठता, वो जमीन कुशन्स पे बैठता है. खिलौने भी हमने ऐसे रखे हैं, कोई बुक्स नहीं है, कोई मैगजीन्स नहीं है, प्लास्टिसीन है, ड्राइंग है, कैरम बोर्ड है, स्नेक्स एंड लैडर्स है. और शुरू सामने एक कुर्सी दिख रही है आपको, थोड़ी सी दिख रही है, ऑफिशियल चेयर, ऑफिस चेयर. वहां पे सुपरिटेंडेंट बैठती है या बैठता है, जिसके पास इंटरकॉम सारे का फैसिलिटी है. एंड ऑल कोर्ट्स नो द इंटरकॉम नंबर. तो आपने ऑडिट किया, आपको संडे वल्नरेबल विटनेस की एविडेंस रिकॉर्ड करने की स्टेज आई, तो आप इंटरकॉम में आपका कोर्ट रीडर या एलमत या कोर्ट ऑफिसर जो भी है वो फोन करके पता कर लेता है किस दिन किस टाइम पे ये वल्नरेबल विटनेस कोर्टरूम अवेलेबल है. याद रखिएगा कि एक ही कमरा मिला था और 80 जज है, उस टाइम तो 80 थे, अब तो बहुत ज्यादा होंगे करकड़डूमा में. तो कितने वल्नरेबल विटनेस होंगे. आज की तारीख में तो पॉक्सो के एक एक जज के पास 400 पॉक्सो के ही केसेस हैं. तो ये कमरे का कितना डिमांड था, तो ऑडिट करना और शेड्यूल मेंटेन करना बहुत बहुत इम्पोर्टेंट है. एंड कैरी ऑन.
Toilet have been crafted out of the corridor, which was available in close proximity to the courtroom. Arrangement has been made for a computer, intercom, table, and chair for the court supervisor. A relaxed environment has been created in this area. Different kinds of furniture, toys such as carom, ludo, painting materials, stationery, plasticine, playing clay, etc. are provided. A washroom is also made available to ensure the comfort of the witness. As children may be prone to suggestion, it is ensured that there are no pictures or photographs on the walls. The pantry supplies filtered drinking water, facilities for making tea and coffee, a fridge equipped with drinks and fruits, and adequate dry snacks for those waiting. If the case spills over the lunchtime, food is made available from the canteen.
ये बहुत important है, you know. First comfort level is giving some element of food and dignity. When we started using this facility, and हम गाड़ी भेजते थे victims के लिए लेने के लिए, तो बहुत resentment होती थी victims की कि सारे पड़ोसी को पता चल गया, सारे मोहल्ले को पता चल गया कि हम आज कोर्ट जा रहे हैं. लेकिन जब उनका एक्सपीरियंस इतना अच्छा होता था, इतनी रिस्पेक्ट के साथ वो ट्रीट किए जाते थे, तो वो होप करते थे केस adjourn हो जाए और नेक्स्ट स्टेज पे वो अपने रिलेटिव्स, ताई जी, चाची, दादी, फ्रेंड्स सबको लेकर आना चाहते थे कोर्ट दिखाने के लिए कि देखिए हम कहाँ जाते हैं और क्या ट्रीटमेंट है. सो ये तो स्नैक्स वगैरह है अगर केस होने वाला है, लेकिन कई बारी सुबह आता है विक्टिम और शाम को 3 बजे 4 बजे एविडेंस होती है, तो हम उनके लिए लंच भी प्रोवाइड करते हैं.
The existing judge's chamber stands converted into the vulnerable witness deposition complex is an in this area. Plasticine comfort of the witness over the lunchtime room, which has.
Now on the left side you see a judge's chamber, and on the right side you see what we have done to it. इसमें कोई स्ट्रक्चरल चेंज नहीं है. फर्नीचर हटाया है, एक सोफा रखा है फॉर एन ओल्डर विटनेस जो आलती पालती मारकर सोफा पर बैठेंगे. Chair and table, there should be better table and chairs. Suppose a witness has some notes that she wants to refer to or some document has to be shown to her, and there's a carpet for a child who wants to sit on the ground. 1.5 साल का बच्चा तो ना सोफा पे बैठेगा ना कुर्सी पे बैठेगा. एंड नीचे वाली स्लाइड में आप देख लीजिए कार्पेट के ऊपर लिखा एक LCD है, और राइट साइड में कोने पे अभी आपको आगे बेटर विजन मिलेगी, एक 360 डिग्री कैमरा है जिसके तहत सारा टाइम वो कैमरा ऑन रहता है. पूरा कमरा इज अटैच्ड टू द LCD. दिस कैमरा इज अटैच्ड टू एन LCD इन द जजेस कोर्ट. अब सब क्या लगा हुआ है, आजकल ट्रायल्स कर रहे हैं, सबके पास कंप्यूटर्स हैं, PCs हैं, LCDs हैं दीवार पे लगे हुए, जिससे कि द विक्टिम, द विटनेस is in full view of the court all the time. Also, whatever is said in this room is simultaneously, contemporaneously, उसी वक्त relayed to the courtroom. So, जो constitution की requirement है, जो CRPC की requirement है, that a trial can be only in the presence of the accused, you have confirmed to that. You have, you know, some amendments have been made in the Evidence Act, but video linking and all, etc., is not completely still provided for. The guidelines speak of that. But we have enabled. Why do we have an LCD in this room? Suppose an identification exercise has to be effected of the accused. So there the accused and जिनके साथ आप mix कर रहे हैं वो कोर्ट में रहते हैं, and victim यहाँ से identify करती है from the victim room. Please proceed.
To be very close to the waiting area. It also provides for a variety of seating choices to cater to the requirement of different age groups, just as in the waiting area. For instance, carpets and cushions have been placed for small children. The deposition room is equipped with a 360-degree camera, earphones,
We've seen the 360-degree camera. Why do we have these earphones? This is for use by the facilitator. Facilitator हम use कर रहे हैं legal aid lawyer. It could be anybody that the judge appoints to assist the trial. ये facilitator witness के साथ कमरे में बैठता है और the judge electronically, judge के पास mic है, ऐसा mic तो होता है room में, या छोटा आप जो भी microphone use कर सकते हैं, उससे the facilitator को question convey करता है. जो prosecutor के question है वो भी judge को दिए जाते हैं and they are conveyed. Defense lawyer का cross examination भी judge के through facilitator को दिया जाता है. Facilitator puts it to the witness. ये इतना सस्ता equipment है. उस टाइम तो वायर वगैरह की जरूरत थी. 2012 की बात कर रहे हैं. आज की तारीख तो आपके तो ब्लूटूथ और पता नहीं कितनी टेक्निकल एडवांसेस हो गई हैं. There is not a person in this room who doesn't use them. आप फ्लाइट पे जाते हैं, आप फिल्म देखते हैं, वो वायरलेस है, कोई एक्सपेंस इन्वॉल्व नहीं है, वन टाइम एक्सपेंडिचर है. Any court can afford this. The district judge के पास budget होगा to buy earphones also.
for the support person, a non-obtrusive.
Now this is the mic that we were using. This is it was just kept there. So whatever said in that room, question put by the facilitator, वो भी सुनाई दिया जाता है. It is attached to the courtroom. The answer by the witness is also simultaneously conveyed to the courtroom, to the judge and the accused persons.
The mic for the witness and LED facilities for identification purposes. The victims are accompanied by a support person. In the attached courtroom, the judge takes the questions from the prosecution and the defense counsel. These are electronically conveyed by the judge to the support person who is provided with earphones. These are put by the support person to the vulnerable witness, which are then answered by the victims and at the same time conveyed to the court using a mic and a 360-degree camera. They are viewed on the LED screen installed in the court. The entire deposition room and witnesses.
So, it's some studies conducted by foreign universities showed that if the victim was kept away while giving her evidence from the judge, तो उनको बहुत hurt feel हुआ. They felt that the judge is the person who can mitigate their pain. Judge ही है जो relief दे सकता है pain से. So अगर तो victim से पूछा जाता है कि आप कोर्ट में बैठना चाहेंगे या witness room से, और अगर witness कहता है कि उसने कोर्ट में बैठना है, तो then we have created this ये red sofa जो दिख रहा है. Again, this is not standard. You can use small chair here, but we had this available, so we use these sofa for the facilitator and the victim are put on the chair. The dais judge का substantially lowered है, almost on eye level with the rest of the room है. ये भी पुरानी building थी, मतलब पुराना courtroom बना था, तो dais raised था, it couldn't do much there. लेकिन अगर witness court में है, तो accused को क्या किया जाए? तो accused के लिए हमने ये side में अहमद का कमरा जो था, उसमें एक दरवाजा बनाया. This is where the engineers helped. और एक खिड़की बनाई जिसमें one way glass लगाया. One way glass का ये मायना था कि उस कमरे से तो वो कोर्टरूम पूरा देख सकते थे, लेकिन कोर्टरूम से कमरे में क्या हो रहा है नहीं दिखता था. और उधर हमने एक स्पीकर लगाया जिससे कि कोर्टरूम में क्या हो रहा है सुनाई दे. अंदर से देख तो वो पूरा सक रहे थे, प्लस एक इंटरकॉम दिया कि वो अपने वकील से बात कर सके अक्यूज पर्सन. तो इस ऐसे सुविधा के लिए पहले जज साहब कमरे में बैठ जाते हैं. ये भी तो पता होना चाहिए कि अक्यूज ही गया है कमरे में, ये नहीं पता चले कि कोई इम्पर्सोनेटर है. तो जज साहब कमरे में बैठते हैं, फिर अक्यूज को लाया जाता है, उस जज से मिला के उसको उस कमरे में बिठाया जाता है एंड दरवाजा बंद कर देते हैं, फिर विटनेस को लाया जाता है. तो दिस इज हाउ वी हैव enabled segregation of the witness.
Are thus fully visible and audible to those in the court throughout the proceedings. The vulnerable witness deposition courtroom has been crafted from existing courtroom in
So what I have already told you that we have used the existing facilities. कोई नई चीज नहीं है. आप ये actually ये film after COVID बनी है तो इसलिए आपको partition दिख रहा है. This was my partition design in Srinagar, in Kashmir, which I designed and sent it to different courts to keep the people separate. But right side में आप देख सकते हैं vulnerable witness का status. Left of that court वो दोनों chairs हैं जहाँ facilitator है, सामने prosecutor and defense lawyers हैं and court staff.
infrastructure. The elevation of the dais is lower as compared to the normal courtroom setup. This is to allow the judge to not be in a position of daunting authority over the people in the courtroom. In case a victim seeks to depose from the courtroom itself, seating for the support person and the witness is provided within the courtroom. Provision was required to be made for the segregation of the accused. This was done by creating a door and window with one-way glass in the adjacent Ahmad's room to enable the accused.
I told you about the adjacent Ahmad room, left side में courtroom है, and ये कमरा craft किया गया from this Ahmad room. बाहर वाला दरवाजा लॉक कर दिया गया है, वो जो कोर्टरूम के थ्रू दरवाजा है वही खुला रहता है, और वो ऊपर आपको लेफ्ट साइड पे दिख रहा है वो स्पीकर है.
Used to see into the court, but not the other way round. The one-way glass ensures a complete view of the witness and court from the offender's side, but not from the other side. This enables a balance between witness protection and fair trial. In the space for the accused,
As I told you, the speaker has been provided to her so that कोर्टरूम में क्या हो रहा है वो clearly सुनाई दे.
a speaker is provided to enable the accused to hear the court proceedings. An intercom also stands installed so that the accused can converse with the defense counsel. This video provided a walkthrough of the vulnerable witness deposition complex in the Karkaduma courts, Delhi. If in your court complex, you do not have a room adjacent to the courtroom for creating the offender's room, you have a very easy option of
Now, every courtroom doesn't have an Elmat room next to it, a court officer's room next to the courtroom. तो आप क्या करेंगे? तो आप, you can take the room, courtroom as it is, and किसी भी corner में, back side में, side में, you can create a space which has one-way looking glass. This was the experience in Karkaduma, where the court staff and the judge's courtroom are on different floors. Judge's chamber is on a different floor. So here in the back of the room, they've crafted out this one-way glass partition so that the accused can be segregated.
available. You can hive off a portion of the courtroom on any side using the same glass partitions as has been done in the Saket district courts in Delhi. The process thus entails the accused being taken into the room after the judge is seated. Thereafter, the victim is brought into the courtroom and placed next to the support person. This facility should be in close proximity, rather in the same complex as the trial court. If this is not so, valuable judges' time shall be lost when they are required to go to another building for each vulnerable witness. In Delhi, the witnesses are being picked up by the person from their homes. In conclusion, it is re-emphasized that minimum adaptation and resource utilization was required for the creation of these facilities. The idea is so simple that every judge can create a temporary vulnerable witness deposition courtroom using his or her own courtroom and chamber, along with simple e-tools like their laptops or personal computers, earphones, and mics. Evidence of every vulnerable witness in any case should be recorded only in such manner. It is stressed that you don't have to wait for elaborate constructions or equipment for implementing the object of the program. Please remember that such special facilities are the need of the hour. Even while you are undertaking the process of creation of the deposition complex, there are temporary measures you may consider immediately. These include, firstly, an audit and identification of cases involving vulnerable witnesses. Secondly, providing a support person to such witness, for which you may train lawyers listed by legal services authorities. Thirdly, permitting separate passage and waiting area to the vulnerable witnesses. Fourthly, using a screen, for example, a portable partition, for segregating the victim from the offender and other persons in the courtroom. Every such measure is one step forward towards the guarantee of equality and access to justice to every vulnerable witness, while ensuring a fair trial to the accused.
So I think all of you could understand what the film was trying to show. And I hope this film helps the engineers. You know, I would request the judicial to share and the committee to share it with the engineers, and so that district judges can interact and ensure creation of such facilities. So to conclude, you know, what I have highlighted is the barriers, what are the barriers to enabling experiences in the court, that law teachers, judges, prosecutors, defense lawyers are all from the same social cultural milieu and carry with them prejudice, bias, discomfort. What is bias? कि जी रात के 12 बजे क्या करी थी सड़क पे लड़की? She was asking for it. So is a comment made by a high court judge, which is so much in the news. 2 days before. आज की तारीख में भी हम ऐसे बोल रहे हैं. या नो नो नहीं बोलना काफी था. वो तो रोज ही उसके घर जाती थी. और she is a prostitute. Where's the question of her getting raped? These are biases and prejudices which we carry in our mind. And we must realize that we have biases and prejudices and rise above them. The second thing is the discomfort of dealing with sexual matters relating to sexual activity. Then we have very little understanding of the dynamics of violence. We cannot comprehend. District judges who went to the Judicial Academy, National Judicial Academy, there were only 200, almost 200 of them in that room. And Professor Mohan Gopal, he was the director of the National Judicial Academy, told me, I happened to be there at that time. He says he was shocked and almost in tears. He said, today we had a discussion on violence. And we talked about violence against wives. And he said, there were so many judges who said, so what if the husband slaps the wife? Or is repetitively violent against the wife? You know, there must be zero tolerance for violence. It is not acceptable. It cannot be said it is culturally acceptable. It is done in our society. Women are meant to be dominated. Man is the dominant partner. I'm not even talking about violence against the other gender. Unfortunately, the Constitution hasn't used the word gender. We talk of gender as a binary between male and female. But the kind of violence which transgenders and people belonging to lesbian and gay community face is unbelievable. Transgenders in the training that we held at Delhi, hijras bolte hai, I think yahan bhi hijra hi bolte hain, kinnar bolte hain in some part of the country. उनको हम नौकरी नहीं देंगे, हम उनको बर्तन मांजने के लिए भी नहीं घर में घुसने देते. हमारी दादी परदादी किसी ने बोला होता है नहीं नहीं इनसे दूर रहिए, ये कपड़ा उठा के ले जाएंगे, बच्चे उठा के ले जाते हैं, फिर हिजड़ा बना देते हैं. ऐसे तो नहीं होता ना. We know we are all educated people, but they say that we have no option, we have no source of livelihood. हमें कोई नौकरी नहीं देता, हमें कोई स्कूल में एडमिट नहीं करता, other than sex trade, and the kind of violence they face even there. वो begging. वो कहते हैं लक्ष्मी त्रिपाठी बड़ी famous activist है, she's a hijra herself. She says, North India में तो बधाई की, प्रथा है. जब किसी के यहाँ लड़का होता है या कोई घर नया लेता है तो they come and dance and we give them money. I don't know whether that happens in Jharkhand, but Delhi, Haryana, Rajasthan वगैरह में तो ये practice है. The rest of the country, there's no such practice. We are only begging because we are ostracized. Supreme Court ने नालसा की judgment दिए हुए कितने साल हो गए हैं. But is there any one of you in this room who will say that they have attended school with a hijra? Have any of your children gone to school with a hijra? The answer will be no, despite the Supreme Court judgment. So, these are the kind of the dynamics of violence we can't even imagine. Lakshmi stood in a room like this in my training, a little lesser, more prosecutors, more lawyers, more police personnel. Lakshmi Narayan Tripathi, let me take one more minute and then close. She's 6 feet almost tall. Now she's become a Maha Guru of something in the Hijra community. She has dark black long hair up to the waist. Khule rakhti hai baal. She wears bright red lipstick, red nail polish, gold, lot of gold, big earrings. She wears very flamboyant saris. She stood in that room in the Saket district court, the training room, and she's asked everybody in the room. She opened her training. I want to ask you one question. Will you answer me? And what was the question? She said, am I invisible? अब आप ही बताइए, जो 6 feet 3 inch, red lipstick, red nail polish, बड़ा, who's so loud in the way she talks and assertive, वो invisible तो नहीं हो सकता. There was stunned silence in the room. She repeated her question 3 times, yet nobody answered. Then she said, am I not audible? They said, yes. Then why aren't you answering? जोर से बोले सब yes. So then said, why aren't you answering? I'll repeat my question. Am I invisible? Everybody in the room shouted out a big no. What she said has imprinted itself on my mind and heart. Her words were, then why, if I am not invisible, then why do all of you treat me so? समझ आया? अगर आप मुझे देख सकते हैं तो आप मुझे ट्रीट क्यों नहीं करते जैसे मैं भी आपका हिस्सा हूँ, सोसाइटी का हिस्सा हूँ? That we also, Hijras also have rights. So next time you see a beggar on the red light, Hijra beggar on the red light, remember what I've told you. They have no source of livelihood. I don't know whether begging is criminalized in Jharkhand. I've struck it down in Delhi. I've struck it down in Jammu and Kashmir. But, in a country where fully able-bodied people, educated people, we are not able to assure livelihood, we must really think of the cause of the livelihood. Somebody is asking you for money to feed themselves because they have no source of livelihood. Why don't they have livelihood? Because we have ensured, we've discriminated them. So, what I have said here is that we don't understand the dynamics. We don't understand the dynamics of violence against many in the community, the trauma and development, which is not given. It is not given importance. And thirdly, hopeless training of judges and prosecutors and sensitization, lack of sensitization in these areas. हम bias की अब बात ही करनी हमने छोड़ दी है, prejudice की हम बात ही नहीं करते हैं. Bias is inherent. आप कोर्ट में बैठे हैं, आपके पास 100 केस लगे हैं, 150 केस लगे हैं. अरे 3 बज गया, अभी तो 50 केस ही हुआ है, अब जल्दी जल्दी निपटाना है. What do you do? अरे this man comes. Poor thing, she's filed a divorce case on the ground of cruelty. अरे जीन्स पहन के आई है, स्लीवलेस शर्ट पहन के आ गई है, इतना लाउड पर्स, एक रेड कलर का पर्स लेके आई है. Look at the heels she is wearing. इसके साथ इसके हस्बैंड कहाँ से वायलेंस करेगा? ये तो कोर्ट में ऐसे पेश हो रही है ना? बायस हमारे माइंड में मन करता है ना जल्दी से निपटाओ, adjourn करो केस या फैसला दो उसके खिलाफ. अगर आप कहेंगे कि आपके दिमाग में कभी ऐसा ख्याल नहीं आया है तो आप सब झूठ बोल रहे हैं. We must be able to realize, understand कि हमारे पास ये we are carrying this bias inside us and rise above it. above all prejudices. And lastly, we must remember, what an intimidating experience it is for a witness to come to the court, which completely traumatizes the judicial process and the experience of the witness. So, what does the success of not my program, our program, for ensuring real justice, substantive justice, ensuring that one small stakeholder, a vulnerable witness in the system, not only which begins in the court, it begins at the police station immediately after the trauma. It continues in the hospital where the medical examination is conducted. We must ensure, at least in the courtroom, that we display judicial leadership, judicial statesmanship, and judicial intervention to ensure that we are enabled to minimize the traumatization. I'll stop here. I thank you all for your very patient, participation. And if there is time, brother Ananda, I'm happy to take any questions. आपको कभी भी कोई भी doubt हो, तो my emails are available. Mr. Ravinder Sharma is here. Ajit is here. आपको उनसे मिलवा भी देते हैं. अजीत, रवि जी आइए. अजीत आइए. इतना valuable contribution है.
We
He is
have
the
some questions.
registrar attached to the. इधर आइए, आप कैमरा में आ जाएंगे. This is Mr. Ravi Sharma. Ravi ji, namaste कर दीजिए. And Ajit Jha. So इनका बहुत contribution है. They are the ones who collate the information. We are in the process of trying to create a website, and we hope that we will be able to say shortly that every district, if not every courtroom in Jharkhand, has been equipped with special facilities, of course with the help of our very learned engineers, and we'll be able to introduce sensitized systems into the police and the hospitals as well. Questions, brother?
There's a question. I'll request Mr. Anil Pandey, who is there online. Unmute yourself and please put your question.
Yes.
Mr.
Witness Protection Scheme.
Judge, family.
Witness Protection Scheme 2018 has given some guidelines to protect the witnesses outside the court, but what measures has been taken by the government is still not known to the courts.
This is something which the brother Ananda will handle. So we are confining this discussion to vulnerable witnesses in the courtroom. And there's no reason why you can't follow the guidelines. You don't have to restrict yourself to guidelines framed under the family court, because these जो हमारी guidelines है, they have the seal of approval by the Supreme Court, the full court, the Jharkhand High Court. Next question.
Next is one.
Sir. Very good morning, ma'am, sir, and everyone. Sir, I am.
Video on करिए ना.
Ma'am.
अच्छा, if you can't.
Yeah, ma'am, there is my camera is not working properly, ma'am. Therefore, I'm really sorry.
Okay.
Ma'am, I am a public prosecutor posted at Ranchi, so we face with witnesses every day. I have encountered a few situations where witnesses actually don't know about the scheme. I have as a public information officer also, I have tried to counsel them that there is a scheme. But is there any compulsion that we have to display this information somewhere in the district prosecution office or in the court complex about the vulnerable witness scheme?
No, the scheme, the courtroom will be visible and the judge will use it, तो automatically पड़ेगा. एक बहुत important चीज रह गई थी. What came in the film, that some of the high courts have reported that they are setting up complexes. Now you अगर vulnerable witness complex trial court के बाहर है, तो कोई जज जाना ही नहीं चाहेगा. आप सोचिए आप आपका कोर्ट छोड़ के जाएंगे, स्टाफ लेके जाएंगे एक विटनेस की एविडेंस रिकॉर्ड करने, बहुत जुडिशियल टाइम वेस्ट होगा. So every effort should be made to develop these facilities within the court complex, within the district courts itself. So अब जो publicity देने की बात है, वो तो आप पहले facilities create करिए, उसके बाद the High Court will undertake this exercise and public PRO of the High Court. But हम लोग as judges, we speak only through our judgments. हम लोग publicity नहीं देते हैं, पर ये facility judge has to use. You don't need to publicize it to members of the public. Next question.
Thank you, ma'am.
It is what I would suggest, that it is you who have to give the facilities to the witness. So
Sir.
You who have to know what facility you have to give. You have to be sure, and you
Sir.
have to be confident enough that these are the facilities which the witness have to get.
Sir.
Once witness enters the court complex,
Sir.
he should start getting the facilities. It is for the court and your prosecutors to ensure that he gets.
Sir. Thank you, sir.
यहाँ room में कोई है?
Anyone from the audience over here who are present physically?
The engineers, police, anybody? Nobody.
From Jamshedpur, someone is raising hand, I think.
Yes.
Yes.
सर मेरा नाम अभिनव हुआ सर, डीएलए से जमशेदपुर से बोल रहा हूँ. सर मुझे ये जानना है कि ऐसे विटनेसेस जहाँ पे विक्टिम है और वनरेबल विटनेस है, जिनका एक्सप्लॉइटेशन हो रहा है, जिनको जबरदस्ती विटनेस के तौर पे खड़ा किया जा रहा हो या एक्सप्लॉइटेशन किया जा रहा हो, उनके लिए क्या है सर? उनको कैसे आइडेंटिफाई किया जाए या उनको कैसे प्रोटेक्ट किया जाए?
माफ करिए, समझ नहीं आया, 1 मिनट दीजिएगा, अभी जवाब देते. क्वेश्चन क्या था? तो वो तो ऑल द मोर रीजन कि आप ऐसी सुविधा यूज करेंगे, आप आइडेंटिफाई करेंगे एंड आप टेक एक्शन अगेंस्ट एनीबडी. वो तो पॉक्सो का ऑफेंस हो गया. आईपीसी में ऑफेंस है, किसी को गलत विटनेस लेकर आप प्रोड्यूस करें. कंटेम्प्ट ऑफ कोर्ट यूज कर सकते हैं. बहुत ज्यादा मेजर्स हैं, आप लीजिएगा स्ट्रिक्ट एक्शन.
I would like to add something. See, आपको ऊपर अगर केस आपका पास अब जो केस हो रहा है, all judicial officers and the prosecutors, आपका पास चार्जशीट आते हैं. चार्जशीट में विटनेसेस का नाम लिखा हुआ रहता है, साथ में केस डायरी रहता है. So आपको थोड़ा रिलेट कर लीजिए, do some extra work, both the prosecution and the judicial officer, and both should be on the same page in this issue, that identify, as madam said, identify that out of the total number of witness, who are the vulnerable witness and what is the degree of vulnerability of each of the witness. If you can prepare this, then it will be easier for you to deal with each type of witnesses, these type of witnesses.
उन केसेस को मार्क करिएगा, फाइल्स को मार्क करवाइए अपने कोर्ट स्टाफ से और कहिएगा भूलने देंगे तो एक्शन लेंगे आप कि ये वल्नरेबल विटनेस है. और जब तक ये सुविधा नहीं आप क्रिएट कर सकते हैं परमानेंट वल्नरेबल विटनेस रूम, तो आप स्क्रीन्स यूज करिएगा. जो डॉक्टर के क्लिनिक में एग्जामिनिंग रूम के एग्जामिनेशन रूम के स्क्रीन्स होते थे, तो ये सब यूज करिएगा कि जिससे कि आप सेपरेट कर सकें. एंड ट्राई टू सी हाउ यू कैन सेपरेट द वेटिंग एरिया. कोर्ट मास्टर को कहिएगा कि ये रिपोर्ट करें आपके पास जो ही ये वल्नरेबल विटनेस आता है. आईओ को बोलिएगा, आप टेक एक्शन. आप बोलिएगा आपके कोर्ट में जो पुलिस के पेशगार होते हैं कि आपको वो स्पेशल केयर रखे वल्नरेबल विटनेस की. प्रोसिक्यूटर को बोलेगा द इवनिंग बिफोर ही मस्ट आइडेंटिफाई वल्नरेबल विटनेसेस का केसेस, यू नो. बट डू एन ऑडिट. ये सबके सबको ऑडिट इमीडिएटली करना चाहिए. टाइम बाउंड बोलिएगा अपने स्टाफ को, कितना फाइल होगा देखने के लिए कि वल्नरेबल विटनेस है.
Moreover, it is for the public prosecutor to decide which witness to be examined and which is not. So, if you feel that a witness is not necessary for a case, you cannot examine that witness. It's not necessary that only because a person has been cited as a charge-sheeted witness, he or she is to be examined.
One from the audience, any questions, any queries you have?
What raised his hand? Sanjay
Sanjay Shah. Sanjay Shah has raised his hand. Anyone?
Thank you very much, everybody, and all the best. I look forward to better reports, more reports from Jharkhand. I'll get a very good report that they have notified the guidelines. We'll do a session on guidelines so that you feel more empowered. कि आप क्या-क्या कर सकते हैं.
Thank you so much, Honorable Ma'am, for this insightful and sensitizing session, particularly for highlighting the challenges that witnesses and victims have to face while dealing with judicial as well as infrastructural setup at the courtrooms. We believe that the participating stakeholders must have taken a note of their role and responsibility in making the judicial and infrastructural support system more accessible for witnesses. With this, we come to the end of the session. I request Shri Satyakam Priyadarshi, Director in Charge, Judicial Academy, for vote of thanks. And after vote of thanks, I request the officers to remain seated for national anthem. Thank you.
Thank you. Honorable dignitaries, esteemed participants, brothers and sisters, good afternoon to all. It is indeed a great privilege and honor for me to propose the vote of thanks on behalf of Judicial Academy, Jharkhand, at the conclusion of this important and impactful training program on creation, conversion of existing courtrooms into vulnerable witness deposition centers for judicial officers, prosecutors, police officers, panel lawyers, officer of the building construction department. At the outset, I extend my heartfelt gratitude to Honorable Mr. Justice Ananda Sen, Judge, High Court of Jharkhand, and Chairman, Vulnerable Witness Deposition Center Committee, High Court, for gracing this program with his inspiring introductory remarks. My Lord vision and leadership have been instrumental in guiding the initiative toward building a more sensitive and accessible justice delivery system for vulnerable witnesses. We are equally honored by the esteemed presence of Honorable Mr. Justice Anil Kumar Chaudhary, Judge, High Court of Jharkhand. Lordship support and encouragement toward this initiative have further strengthened our collective resolve to make justice more accessible and human for most vulnerable. A very special and sincere thanks to Honorable Mrs. Justice Geeta Mittal, former Chief Justice of Jammu and Kashmir High Court, Chairperson, Vulnerable Witness Committee, Supreme Court, for her gracious presence and for delivering such an insightful and enriching sessions. Ma'am, your deep understanding and passionate advocacy for the right and dignity of vulnerable witnesses have enlightened us and motivated all stakeholders to work with renewed commitment. I would also like to thank Sri Ravinder Dutt Sharma, Registrar Vulnerable Witness Deposition Committee, and Sri Ajit Kumar Jha, Director, for their support and valuable insights. Their leadership at the national level has been pivotal in shaping and framework and momentum for vulnerable witness protection across the country. A special word of thanks goes to Sri Nikesh Kumar Sinha, Registrar, Judicial, High Court of Jharkhand, cum Nodal Officer, Vulnerable Witness Deposition Center, for his continuous guidance and commitment, involvement in the planning and implementation of this program. I would like to thank Law Secretary, Member Secretary Jhalsa, Member of the Registry of the High Court, for their presence. I also take this opportunity to thank all the respected judicial officers, prosecutors, senior police officers, panel lawyers, and officials of the Building Construction Department who participate actively in today's training. My heartfelt appreciation goes out to my colleagues, the dedicated faculty, staff, and members of the Judicial Academy Jharkhand, who, like a family, work tirelessly behind the scenes to make this program a success.
I also wish to extend my thanks to the media personnel present here. I hope this contribute to raising awareness and support for vulnerable witness protection. Once again, thank you all for your presence, your contribution, and your support. Let us continue to work together with dedication and empathy to build a judicial system that is truly inclusive, secure, and just. Thank you.
There are two small announcements. First is regarding group photo session. We have group photo session with the honorable dignitaries. In the first group, we'll have all the judicial officers, and in the second group, rest of the officers from rest of the departments. After this, there shall be lunch. We have made arrangements for lunch for the judicial officers in the dining hall of Damodar Hostel, whereas for rest of the officers in the cafeteria. With this, we come to an end of this session. I request all to rise up for the national anthem. Thank you.
चलो खत्म बहुत बकवास
पंजाब सिंध गुजरात मराठा कावेर उत्कल गंगा हिमाचल यमुना गंगा उज्जल जगत तब शुभ तब जय जय हे पालक भाग्य विधाता जय जय हे